of 4 streams of events, FSR debates, insights, talks, and conversations, every Wednesday, typically at 2 p.m. Today, we have a debate on some recent case law. We will be looking at 4 cases in particular, and then we will also be referring to others. I'm really, really happy that Lee Henscher from the FSR is going to lead the discussion on this. I'm also very grateful for Liliana Eskenazi from Frege & Associates, who will be also presenting some of the cases. And we also have Fabien Roch from Compass Lexicon and Paris Dauphine University, and Francesco Salerno from Gianni Origoni, Grippo Capelli and partners, joining later on for and providing some comments. So I don't have much to say except that this is different from the previous debates. The format is a bit different because the topic is a bit different. So we'll have not necessarily a panel debate, but just reactions from the 2 commentators. But most of the presentation time will be actually taken by Liliana and Lee in presenting these cases. And then we hope they will have a couple of polls, and then we also hope to have some questions, some time to deal with questions from the audience. So please use the facility in the platform to submit questions, and I will pick a few of them towards the end. So without further ado, I pass now the screen to Lee Henscher for starting the presentation of the cases. Between her and Liliana, they will present 3 cases on dispute resolution, the competencies of national regulatory authorities, and also state aid. Lee, the screen is yours. And I guess you need to unmute yourself.
Okay, I think it works now, yeah?
Yeah, it does.
Good, thank you. Thank you for the kind introduction, and I'd also like to welcome Liliana today. This is a format we used earlier this year to bring the audience up to date on some recent important cases that affect energy law and policy. So I will kick off with, I think, for many energy lawyers, one of the most important cases in decades. And in fact, for state aid lawyers generally, quite a surprising case for a number of reasons, which I'll come back to. So I will talk about Hinkley Point for about 10 minutes before passing then to Liliana, who will also review 2 very important new cases. So the Hinkley Point case, its official name is Austria versus the Commission, and it's a ruling of the Grand Chamber, which already means that it's important because the Grand Chamber then sits on major cases. To give you a little bit of background, way back in October 2014, the Commission adopted a positive decision on the UK's plans to give aid to the first nuclear power plant that would have been built in the UK for many, many years. The UK had come up with a very complicated way of financing this new plant, partly in fact because they thought they might even avoid the state aid rules entirely, but then they realized that that wasn't going to be the case. That was particularly because the type of aid or support to Hinkley was based or is based on a number of instruments, one of which is a form of contract for differences, at which the power company takes the volume risk, but not the price risk, because the price is fixed by way of a strike price or an administrative price in advance. And that price is actually very, very high. And some people say that the British government had even sneakily hoped that the court might have quashed the Commission's decision and they could have got rid of this aid altogether. But that's not exactly what happened. However, back in the day, in 2014, the Commission supported then the UK's reasoning on this case. It was challenged by Austria, supported by Luxembourg, in the General Court. There were, in fact, other parties who challenged the decision at the time, such as Greenpeace, and also some small German producers of CHP, of combined heat and power, but those actions were rejected as inadmissible. And actually, it's very important that Austria challenged, because in EU law, a member state can always challenge a decision of the Commission. It doesn't have to show that it has any special interest to do so. And in fact, it's very rare for one member state to challenge a decision granting aid to another member state. In fact, I believe this is the first time that such a thing has happened. Before the General Court, Austria lost, and without going into too much detail, the General Court found that it was not necessary for the Commission to have identified the Hinkley project as an object of EU-wide common interest. So it was sufficient that it was in the national interest or the national public interest for it to be potentially compatible. Similarly, and for the economists, something of a bit of a shock, I think, at the time, the General Court said the treaty, the rules on compatibility of state aid do not require the Commission to establish that the aid is there to correct a market failure. There's no such mention of this term in the treaty. Finally, the court said, of interest for us at least, that the Euratom Treaty is a separate treaty, and that the principles that we find in the treaty, the TFEU, the Treaty on the Functioning of the EU, and the TEU, those principles are separate, and they do not then have to apply to the Euratom Treaty, which is a kind of a lex specialis. Austria lost. Austria appealed, and on, of course, the way to the final ruling by the Grand Chamber in September this year, we had in the early spring of this year the opinion of the Advocate General, the Irish Advocate General, Hogan, which was a very interesting document for state aid lawyers, at least, as he took a very strict interpretation to both the Euratom Treaty and to the rules on state aid in the TFEU, or the Lisbon Treaty, and said these two treaties had to be very strictly interpreted. Interestingly, he viewed that the main treaty article on state aid compatibility, that's 107, Article 107.3 little c, could only be very literally applied. So the only grounds on which the Commission had to check whether the aid was compatible or not was its impact on competition and trade, as is provided in Article 107.3. And its impact or negative impact on the environment or whatever did not have to be taken into account. So that was quite a surprise, because many commentators looking at that opinion thought, oh, we cannot use European state aid law as an instrument of positive integration, that we can add compatibility criteria like even security of supply, or protecting employment, or various environmental goals. That didn't seem, at least in Advocate General Hogan's interpretation, possible. Anyway, we don't have time to go into that in too much detail. Let's get to the ruling of the court. Now, it's quite a detailed ruling, but not as long, thank goodness, as the General Court's ruling. And basically, I just want to highlight a few main points here. The court confirmed what the General Court had said, and indeed its Advocate General, that this Article 107.3 little c, the main grounds for compatibility testing used by the Commission in most cases, is not dependent on a finding that of the aid pursuing an objective of common interest. And the court goes on to say that the objectives pursued by the European Euratom Treaty, the Special Treaty on Nuclear, which does not contain state aid rules, and this is why this case is very important. It's the first time the courts had to look at the relationship between these two treaties. So the court said, well, the fact that the objectives of the Euratom Treaty cover the construction of nuclear power and the creation of new nuclear energy generating capacity does not mean that the grant of state aids for them is not contrary to those objectives. In other words, even although the Euratom Treaty promotes nuclear power, that doesn't mean to say that it gives a carte blanche to member states to finance that construction of new plants in any which way they choose. So the Euratom Treaty it has no state aid rules, so we have to go back to the Treaty of Lisbon rules. And so the court proceeds then to look at how those rules impact this project. It confirms that the General Court was correct on the relevance of a market failure or not to the analysis. And they're a little bit more, I think, softer, less categorical than the General Court, because here the court says, the Court of Justice says, well, the existence of a market failure can be relevant to declaring state aid to be compatible. So if you're remedying a market failure, that's a relevant argument. But the absence of such a failure does not necessarily mean that the compatibility criteria as laid down in Article 107.3 little c can never be satisfied. So that means, of course, that the objectives pursued by the aid are very much left to the member states, and those familiar with state aid rules and the guidelines that we have on energy aid, which of course don't apply to nuclear but apply to other forms of aid, require that member states establish both that the aid targets an objective of common interest and remedies a market failure. So just going on quickly to the next couple of slides, what is very important in this ruling is that the court is quite categorical that the aid can only be declared compatible if it meets the general principles of environmental protection, so the polluter pays principle, etc. And these principles are also applicable to the nuclear sector. So there, the court does not follow the General Court, and it does not follow its Advocate General. So it's not only important that the court recognizes that these principles are paramount and the Commission cannot declare an aid compatible that would be in contradiction of these principles, these treaty principles, but it also says that the same is true of the provisions of secondary EU law on environment. So if those provisions in secondary law apply, then the aid cannot be declared compatible. And for those who love reading the footnotes in case ruling in these judgments, the court refers to an earlier case which actually does not say what the court says. It says here. Anyway, moving on to the last slide that I want to just draw your attention to. So when we look at compatibility, it's common knowledge that we conduct, or we require the Commission to conduct a balancing test to weigh up the positive against the negative effects of the aid. And here, this is where I think this judgment that was handed down in September has really got everybody rather concerned, because what the court says here is it goes back to the wording of the treaty, and it says, well, the Commission has only got to take into account the negative effects of state aid on competition and trade between the member states. And so the General Court didn't err in finding that the Commission did not have to take into account the impact of the environmental principles, and the detrimental impact, for example, of the aid on the environment, the precautionary principle, the polluter pays principle, and the principle of sustainability. So all those principles are out. All that the Commission has to do is to look at competition and trade. And I think when we come back to the discussion, we can pursue that. Thank you very much. So I will now switch to Liliane, who will go on with the next cases. Thank you.
Thank you very much, Lee. Let me just share my screen first. Thank you very much for the invitation. I will be speaking about two rulings. Sorry. Can you see my screen now? I will be speaking about two relatively recent rulings. The first one of the Court of Justice on a preliminary reference from the French Cour de Cassation, and the second one on judgment upon referral of the General Court, which is a long saga also in a French case. So without any further delay, I will start with the judgment of
Liliane, can we just ask you to put it into the full screen mode for your slide?
So the first case is the judgment of the Court of Justice in the preliminary reference in the GRDF case of 19th of December 2019. I will, since it is a preliminary reference, I will mainly address the legal implication, the general legal implication, but I thought it will be interesting to see the kind of peculiarities of the French setup and why this case went quite technical case went all the way up to the Court of Justice, and how it impacts the interpretation of the role of regulators, especially in the context of liberalization in regulated sectors. So by way of just reminding what the background is, it's the dispute between Direct Energie, which since has become Total Direct Energie, which is one of the main, actually the main alternative operator in France. It's a gas as well as electricity supplier. And it was a dispute with GRDF, which is the DSO, the French DSO. The dispute arose in the context of the so-called contract in the court judgment. It's called contract for transmission of gas. Actually, it's about distribution, but basically, since the very early years of liberalization of gas supply, energy supply in France, suppliers have been bound by this contract with the DSO for the service of gas supply, which they then sell to the final customer. And the dispute arose because according to the DSO's interpretation, so GRDF's interpretation, once GRDF had its contract with Direct Energie or with other alternative suppliers, it was their duty to manage customer relation as well as the risk to take charge of the risk of unpaid bills. And which, of course, is a huge charge for alternative operators, for new entrants on the market, because it meant that whenever a customer didn't pay their bill, and unfortunately it happens a lot, that charge is on the supplier, so in this case on Direct Energie, and the supplier had just to pay the bills on behalf of the final customer, even though the customer had not paid. And it's came to quite important amounts of money, so in terms of millions of euros of unpaid bills that the alternative operators had to pay to GRDF before even they got paid by the customers. The other aspect was the customer management. Whenever there was an issue with gas distribution that was related to the distribution system, it was the supplier that had to deal and to deal with customer complaints and to put into relation, if needed, with the DSO, with the distribution system operator, for no cost. That means do this service for free. Now, obviously, this is also an important charge. And so Direct Energy went to the regulator in dispute settlement and asked the regulator to assess this clause. And the regulator said, indeed, this is contrary to national provisions because it puts an important charge. There was some subtle legal interpretation saying that actually GRDF is not selling to Direct Energy, to the supplier, this service of gas distribution, and then it's up to the supplier to manage the customer relation. The supplier was only an intermediary, and actually the contractual relation, if I get back to the scheme, the contractual relation is directly between GRDF and the final customer, which means that if there is a problem with the payment of the bills, or if we are talking about client service in relation to the distribution system, it is the burden of this is upon GRDF and not upon the supplier Direct Energy. So this is basically what the regulator said in its dispute settlement role. And what it said, moreover, was that the GRDF had to modify its contract in order to get it compliant with this finding, and to amend it retroactively, that is, since the very beginning, since the beginning of the contract itself, to make it compliant, regardless of the date on which the dispute arose. So this went on appeal to the Paris Court of Appeal, which confirmed with some further clarifications. And GRDF, unhappy, brought an appeal before the French Cour de Cassation. And this is where the Cour de Cassation asked its preliminary question to the ECJ. Which basically consisting in asking for interpretation of Article 41 of the Gas Directive of 2009, asking whether this directive required that the regulatory authority has this power to issue decisions that are applicable to the whole period of the dispute, basically whether it had these retroactive dispute settlement powers. The court, in its ruling, referred to several provisions of the directive of 2009 and also of 2003. Which I will not quote in detail, but basically which deal with the powers of regulators, and also on the substance about the obligation of DSOs, basically to ensure third-party access without any discrimination between suppliers. So the debate before the Court of Justice was about these two aspects. On the one hand, on the merits, whether it was an issue of EU law, these very specific contractual provisions, which in the first instance were considered incompatible with national legislation. And so what was the issue from an EU law perspective? And in the end, the conclusion of the Court of Justice was that since there were issues of non-discriminatory access to the market and this burden put on alternative operators was so huge that basically prevented them from competing competing on equal basis with incumbents. There was an issue actually of EU law, and so the contractual provisions that were at stake in the first instance could indeed called for the application of EU law. And the second issue, which was basically the procedural question of the French Cour de Cassation, was whether the regulator had the possibility or even the obligation to settle a dispute in a retroactive manner that is not only limited for the future. The French provision of the energy code relating to the powers of the national regulator was not at all in question. It was basically in line with the provision of the directive, and itself gave sufficient power of the regulator to deal with this issue. What was indeed more problematic in this case was that there was a lot of debate and intervention from the legislator itself to limit those powers. Once the question has already arisen in the context of telecoms. There was a similar judgment a couple of years before in the context of telecoms, where the regulator had decided for a retroactive amendment of contracts between incumbent and alternative operators. This was confirmed on appeal and by the Cour de Cassation. And then the legislator came and limited the effects of this this possibility to amend retroactively the provisions of contracts between private parties. And here the story was a kind of a reproduction of this scenario. There was this decision of the CORDIS, the French regulators dispute settlement body, which said, I am amending this contract because it's not compatible with national law. And by the way, it's not compatible either with EU law, and I'm amending it retroactively. The Court of Appeal confirmed. And when we came to the stage of Cour de Cassation, in the meantime, there was an intervention by the legislator in 2017 saying, further to the Court of Appeal judgment in 2016, I admit that these contracts should be modified, but considering the important consequences for the incumbent that this amendment could entail in terms of how much it's going to cost, I will limit the possibility to go back in time to 2 years maximum. So basically, all the contracts that were concluded before, before a period that went back to 2 years, were retroactively deemed valid. So the Court of Justice was not asked to assess the validity of this legal provision. It was focusing only on the contractual dispute before the regulator, because this is the way that the Cour de Cassation assessed, and the French legislation was not did not apply at the time the Cour de Cassation asked its question. But more generally, the judgment of the Court of Justice raises indeed the question of the protection of the effectiveness of EU law, because if the national regulator does not have enough power to eliminate the consequences of any incompatibility with EU law, including with national law, which is obviously an implementation of the directives in the context of liberalization. Well, it's the effectiveness of EU law itself that could be put into question. So this judgment in the end has a very structuring effect on the on all sectors, not only energy, as I mentioned. Also, it's important in telecoms, and we have seen also recently some developments in the railway sector where the same types of disputes arise. So that is why I think that it has a scope going much wider than the simple context of this technical dispute between between GRDF and Direct Energy. Maybe I should stop on this one and go quickly on my second case, and then I can get back to the details if there are any questions on that. So my second case is the General Court's judgment in the IFP Énergie Nouvelle. I will refer to it as IFPEN for ease of reference. So it's a long saga, French saga again, and this time it's a state aid, purely state aid issue. It was an action for annulment of the decision of the Commission dating back to 2011 regarding French state aid in relation to the transformation of the legal status of the Institut Français du Pétrole. So Institut Français du Pétrole its status was changed to an EPIC, the so-called EPIC, which is a établissement public d'intérêt industriel et commercial. It's a legal person that is governed by public law, which has an economic activity, and it's in legal terms, it's a legal person which is distinct from the state. But it has competencies, has attributions that are related to public service missions. In this case, IFPEN had also 3 subsidiaries, which had, for some of them, economic activities. And the peculiarity of this basically specific establishment is that it can have both economic and non-economic activities. Also important in this context is that this EPIC status had already drawn the attention of the European Commission in a case from 2010, which is La Poste, because La Poste had followed the same path as I may say. It was also at one point going to be an EPIC, but the Commission, but this status basically involved an unlimited public guarantee due to its peculiar status, which means that this entity is not subject to insolvency proceedings. The state is liable for all its debts, basically, even if this entity goes bust and there are debts, there are creditors that come for asking for reimbursement of the debts. The state basically guarantees the payment of any debt. And there is also another advantage, which is the privileged access to state accounts, not exactly the term, but compte d'avance de trésorerie, which is also a facility in terms of access to public funds. So the Commission deemed that this is incompatible state aid, this unlimited public guarantees, unlimited state aid, and this was confirmed by the Court of Justice in its judgment of 2014 in the La Poste case. So all the discussion in the IFPEN case is basically a follow-up of what the Court of Justice said in the La Poste case, and an analysis of whether or not there is a presumption, as long as we are talking about this specific status, whether there is a presumption of advantage, and therefore basically the level of proof that the Commission should demonstrate in order to conclude whether or not there is an economic advantage due to this specific status. I will not go any further because I took already quite a lot of time. I will not go into developing the details of all the judgments, but we'll try to summarize based on this table that that you see, in which I try to kind of present the chronological developments and the subtleties of the legal reasoning of this case. In this case. So the initial decision of the Commission dates back to 2011. And as I said, the Commission concluded that the limited guarantee to IFPEN constitutes state aid. It applied this presumption of the existence of an advantage for both the IFPEN's relations with banking and financial institutions and to its relation with suppliers and customers. So this goes beyond what the Court of Justice had ruled in the La Poste case, where only relations with banking and financial institutions were concerned. All the debates in the following procedural steps and judgments were around, was this justified or not, and how far does the presumption of the existence of advantage go? So the Commission said the presumption applies both to banking and financial, to relations with banking and financial institutions, and to relations with suppliers and customers. He also said that this analysis of the real economic advantage is presumed in both cases, even if it's in this specific situation, it is not observed with the banks in reality, but there was no evidence that it can happen in the future. So basically, it confirmed that it's state aid. So this decision was partially annulled by the General Court in its initial judgment of 2016. It took quite a lot of time because the General Court was awaiting for the Court of Justice judgment in the La Poste case. So in 2016, it's already after the La Poste judgment, and the General Court thought it applied this case law in a very consistent way. It said basically that the presumption applied indeed in relations with banks and financial institutions, but it did not apply in the case of the relations between the IFPEN and the customers and suppliers, and that no real economic advantage was proven regarding these relations with customers and suppliers, which basically were the economic activity managed by some of the subsidiaries of the IFPEN. Unfortunately, the Court of Justice considered that it was a bad interpretation of its own judgment in La Poste, and said that it set aside the General Court's judgment and referred back the case. What the Court of Justice said, that the presumption could apply to relations with both the banking and financial institutions and customers and suppliers. For the first, the presumption was basically automatic, so there was no need for the Commission to demonstrate a real economic advantage. But for customers and suppliers, this presumption was not automatic, so the Commission had to demonstrate that the advantage derived was derived by IFPEN and its subsidiaries was basically similar as the one that it derived with regards to its relations with banking and financial institutions. And in substance said that the Commission should take into account the legal and economic context. So it's very like case-to-case, case-by-case analysis. And I think that the underlying logic of that is that in the La Poste case, it was mainly discussed that, well, since it's facilitating access to credit, to finance, etc., it was kind of natural that the presumption will play in relations with banking and financial institutions, but it was more far-fetched to say that the same advantage was derived in the relations with customers and suppliers. So the Commission had to go further to demonstrate that there was indeed a possibility of such advantage in these type of more commercial relations. So the case was in the end referred back to the General Court, and this is where we have this judgment of last October. So the General Court finally does again this partial element of the Commission decision, but with a different conclusion here. So the presumption of the existence of advantage could apply, as the court said, in relations with banks, as the ECJ said, in relations with banks and financial institutions. In this case, for the past, for the reporting period before the Commission, there was no evidence of real economic advantage. So basically, the Commission itself had kind of reversed the presumption and said, okay, in this case, there is no real economic advantage, even though I still apply the presumption. But this presumption continued to apply even for the future. And so there is basically state aid because there is advantage and therefore there is state aid. And to the difference of the first time around, it said that the presumption also applies in relations between IFPEN and the customer assistance plan, but the Commission here has to demonstrate that IFPEN can have a similar advantage as the one derived from the relations with banking and financial institutions. And in this case, this advantage was not proven. So this is the I will stop here and take any questions if you have, but it's a very legalistic debate about the charge, the burden of proof, basically.
Well, thank you very much, Liliana. Thank you for an excellent job in trying to make intelligible something which seems very complicated. But even someone who is not a lawyer like me, I think I got at least the gist of it. Thanks a lot. Very interesting cases, both of them. I now wonder, before Lee comes back and look at other cases to watch, I wonder whether Fabienne has anything. We should also have Mr. Salerno, I think, connected. I think Fabienne will probably look more at the economic implications, maybe of the Hinkley Point ruling and the criteria for assessing state aid. And perhaps Mr. Salerno can then go more into the legal aspect, and I think there have been a lot of them outlined both by Lee and by Liliana. So Fabienne, would you like to start?
Well, yeah, thank you, Alberto. Good afternoon to everybody, and thank you for having me. Fascinating discussion. Thank you, Lee and Liliana. I enjoyed it. I'm not a lawyer, but I'm always keen to hear the latest developments. I was indeed involved in the Hinkley Point case initially, and maybe I can offer just a very brief comment on this one. As you probably know, I mean, the role of economists in stated cases, I mean, there are two things. There is first whether there is aid, and then there is a compatibility question. And the main role of economists, as we all know, is usually the market economy investor principle, which is the central concept where essentially you have to establish, based on these benchmarks, these tests, whether there is state aid. This is not what we are necessarily focusing here on, but I just wanted to remind everybody of that distinction. Now we are focusing, if I understand correctly, on the compatibility issue. On this one, I mean, clearly the question is what should be the criteria, as we have heard from Lee. And Lee insisted that the latest decision from the European Court of Justice is calling into question, let's put it this way, whether essentially the treaty and essentially the competition dimension of the treaty should take prominence over, I would say, the rest, if I can summarize my understanding of what's been said. And in particular, whether, you know, an assessment on the impact on distortions of competition should not be the core part of the assessment. I'd say on that front, that it doesn't necessarily mean that there cannot be a way for the other dimensions to have a role in the assessment, just because, for instance, as economists, we are used to assessing various types of externalities. What I mean by that is that if you are talking about security of supply, well, this can have a monetary impact. You know, you just need to think about value of lost load. You just need to bring that into a monetary picture, an economic picture, if you want. Similarly, if you think about benefits to the environment, a lot of that can be brought back to economic and monetary issues. Employment effect, well, that would entail macroeconomics arguments. But again, potentially, I would say this is good news for economists like me, in the sense that we could have a broader role based on this definition. So this is just my quick reaction, and I wonder, Lee, if you believe I'm going too far in saying that, or if you think this could be you know, something for a debate in the coming months.
Lee, hi, do you want to react before we ask Mr. Salerno to come in?
Yes, thank you very much. Yes, no, it's a very good point, and I think you know, that the court certainly opens the way for, let's say, monetizing all these additional externalities, calculating them to see what their impact on competition or trade actually is, and that might, in the end, improve the balancing test that the Commission does, because I think many people look to see, they look to the decisions of the Commission, and the Commission sort of, we used to say, writes the conclusions first and reasons backwards in many cases, which are very political. So the balancing kind of is made to suit the outcome. But if we have a more economic approach, which we already have to some extent in the application of certain guidelines, then that might make this balancing test more objective. That might be, you know, a positive thing. But of course, it will complicate discussions as well. It will mean that member states will have to employ economists to do these calculations for them. And that will also in turn, I think, raise some interesting discussions, because of course there's no single way to calculate those costs. I'm sure one group of economists can come up with at least 3 different alternatives compared to another. So that will also be very interesting. The court might have opened a bit of a Pandora's box for itself. I don't know if Liliana, do you want to say anything about this part of Hinkley?
Yeah, well, I should give more the legal perspective. It may be a court judgment that makes economists very happy, but from a legal perspective, I was wondering whether it doesn't go really too far in that. Basically, the court limits the appreciation by the Commission only to competition law and leaves aside all the other objectives, including those that are in the treaty. And then I had a more technical, also legal technical question. You mentioned these the specifics, the contracts or differences, PPAs. Is there any impact of the court judgment on how they are analyzed under competition law? Whether it's operating or investment aid, how is it analyzed basically under state aid law?
Thank you. Yeah, that's a good question. I didn't have time to go into all the aspects of the Hinkley ruling, but one of the important findings of both the General Court as confirmed by the Court of Justice is that the Commission did not have to classify this contract for difference that was the basis of the support to Hinkley as either operating aid or investment aid. And in state aid law terms, if you fall into the operating aid box, that usually means that the aid will not be seen to be compatible because you're just maintaining the status quo. So if you have a contract to operate a nuclear plant, that's not usually going to be seen as compatible because you're just covering the costs that the operator would always have to accrue. Whereas with an investment aid, you're actually required, that has incentive effect, you require the recipient to do something extra. And it wasn't clear from the Commission's decision how to put a contract for difference into this classification. And so the Commission sort of wriggled a little bit out of that. But the General Court said that wasn't necessary. And the Court of Justice has confirmed that the Commission doesn't have to pigeonhole these kind of contracts. So it's really kind of substance over form here that's important. So the court said, well, we can see that this contract for difference is meant to allow for the investment to take place, to give the security to investors. So this is really important, an important signal for PPAs going forward. I think we can all recall earlier decisions of the Commission for power plants in Hungary, where PPAs were deemed to be operating aid. I think there are cases going on in other countries as we speak, where that debate is also still playing out, how to classify PPAs. So this is maybe an important sort of light at the end of the tunnel here, that CFDs, which will, I think, come into fashion in a big way in the energy transition, that these can be seen in a positive light.
Thank you very much. Thank you, Lee. Thank you, Liliana. I would like to bring in Mr. Salerno, who has been listening, and he is a lawyer. So while Fabienne was trying to extract what is interesting for economists, please, Mr. Salerno, what is your reaction to what you've said, what you've heard, and on these three cases?
Yes, thank you, Alberto. Really, if I may, I maybe wanted to bring in yet another case on which I was asked to speak, and I'm grateful for the organizers, which is an ongoing case. It has to do with Italy, so maybe some of us will be more directly familiar with that. It is a reference for a preliminary ruling from the Consiglio di Stato, the highest administrative court in Italy, and it's about green certificates. The case is 705/19. And it's an active case and an ongoing one. So what I thought I would do is just to summarize for you what happened at the hearing that we had in September. And probably the best way to summarize it is to summarize the gist of this case is to think about the famous Italian cocktail, the spritz. The spritz has three parts, and so has this case. So one measure, one part of the case, it's about, it's a rerun of the Allen's case, because here the debate is whether the test the court used in Allen's for green certificates under free movement can be also applied to green certificates in Italy. And so here we will see what the court makes of the second opportunity to rule on an Allen's type situation. The second measure of the cocktail has to do with another strand of EU law. It is the prohibition against the customs duty and measures having an equivalent effect. And here the case picks on a strand in several Commission decisions about support for renewable energy. The Commission has systematically targeted the way in which support for green producers was financed, and typically has hit at member states which penalize imports in the way they finance their green producers. And this is, again, it's another part of this case. And the third measure is a large pouring of a Prosecco. No, sorry, what I meant is a large pouring of state aid, because what really features prominently in this case is state aid. And when we appeared before the court, we had questions on state resources, because here there are intangible assets in the form of certificates, of tradable certificates, and whether the principles of the Dutch NOx case are applicable here. We had questions about the advantage. We had also questions about selectivity. And the court, that's interesting, I think, for people who watch this space. The court wanted us to elaborate on why a measure for green producers is selective, which took us a bit as a surprise, because typically this part of the notion of aid in previous decision is dealt very quickly and almost per se. So this is again another topic on which probably we're all very curious to see what the court will make of this case. And you don't have to wait that much to know what the court, at least the Advocate General, would think, because the opinion is due by December the 3rd, so in a few days. So by then we'll see if it's time for a toast, for a spritz, or something else. So I think with that, I'll leave the floor to the speakers to continue.
Thank you very much. Thank you very much for bringing this other case. Lee, do you want to then go back and either run the polls or refer to the ones to watch cases?
Maybe we could first run the polls, and then we can do the ones to watch.
Please, do you want to run?
Yeah, I think Anne-Marie, can you put them up, or?
Yeah, I think Daniela is about to launch them now.
All right, okay.
Okay, here we are.
So there's, of course, the Hinkley case is very important because it's, as I mentioned, is the first case before the court where the relationship between the state aid rules and the Euratom Treaty rules had to be confronted. And so the question really relates to are we now clearer on the relationship between these two treaties? And yes, I think that the answer is it's interesting. 39% of the people participating think not, but I suppose it depends on whether or not we're looking at the legal framework or the outcome. In fact, here one could say there are different answers to that question depending on how you read the question. But we have a couple more cases, of course, pending involving aid to the Pax power station in Hungary, for example, where the court will get another bite at the cherry. Although we don't know exactly when those cases are going on the court's agenda, but that will be interesting to watch too. Thank you very much. So let's close this poll. Then we have a second polling question. So this we've had a few questions coming through already in the chat box too. The impact of this kind of case law on the up and coming revision of the energy and environmental state aid guidelines that currently are in force. They were introduced in 2014. And one of the cornerstones of those guidelines is that operating aid can only be allowed in very exceptional circumstances. So in fact, to support renewables, for example, that's one of the types of aid that can be allowed as operating aid. But in most other cases, the only aid that's allowed is investment aid. So the question then is, and perhaps you've seen that the Commission has announced in its questionnaire that was published on the 12th of November that this is something they're looking at when they revise the guidelines. So this distinction, is it really a valid distinction? So what do you think? And we've already got a positive reaction. So most people are keen that this classification is reviewed. So maybe we can abandon the form over substance and concentrate on substance over form here. Thank you. All right. So thank you very much for participating in the polls. Now I think we can just turn to the two cases that we selected as ones to watch. So if I can just have my slides back on the screen, and I'll just rapidly go through those. So I'll go to the next one. That was the last one. Okay, So we selected two cases, the Axpo case and the Achema case, or the Achema case. I'm not so good in the Lithuanian pronunciation, so I hope I'm getting this right. Liliana had a very nice table when she discussed the IFIP case, looking at the different sagas or the different stages that case has gone through. Achema is in fact also a bit of a saga case. And these two companies are large energy consumers in Lithuania. And they have challenged a commission decision that ruled as compatible aid in Lithuania to for RES-based electricity, which would be financed through a levy, a renewable energy levy, that would be imposed on these large energy consumers. Now, in many countries, of course, large energy consumers enjoy sort of a bit of a levy holiday, if you like, a sort of tax holiday, and they don't have to pay the full amount. But in Lithuania, they do. Now, for the state aid lawyers, this is a case where the Commission has adopted a decision on the basis of the first preliminary investigation. It hasn't gone into great detail because it did not have serious doubts on the compatibility of the aid, so it didn't open the formal investigation, the second stage of the procedure. So it closed its investigation and declared the aid to be compatible. And that means that these two large consumers have been able to challenge that failure to open the formal investigation. That they say, therefore, this has denied them their procedural rights, because if the Commission does not open a formal investigation, then, of course, interested parties, so competitors, users, whatever, even beneficiaries, they're all interested parties. This is the only formal opportunity they have to make their views known. So this is the single plea in this case, is that the Commission should have opened the formal investigation. And why? What if we can just go to the next slide? A lot of this is because, in fact, these poor industrial consumers, they've been fighting all these levies for almost a decade. And unfortunately for them, they haven't had too many successes, although they have won quite an important case. So they challenged an earlier LNG levy. That was what was required to pay for a new LNG floating terminal that was held to be compatible aid. And that then is financed by this LNG levy, which these large industrial users have to pay. They challenged that. They also challenged what is called a PIS levy, so a sort of public interest levy, which requires them also to contribute to the costs of gas supply. And then now they have this RES levy. So this is a very expensive sort of situation for them. They're paying a great deal, and they felt that they feel that the Commission should have a look at the cumulative impact of all these levies that they're required to pay when judging compatibility, and instead of just ticking off the boxes in the environmental aid guidelines. So that will be an interesting case to watch. And here, of course, we're talking about the EAG and how the Commission should apply that. Moving on then to the next case, the Axpo case, which our colleague Francesco just described as a form of spritzer. This really just summarizes what he already said. He recalled that this is a referral from the Italian Council of State, which concerns then whether or not green certificates are a form of aid or not. And the Council of State has referred a number of questions to the court, some of them involving the definition of state aid and whether or not these green certificates are a form of state aid. And so if I could have the next slide, please. Again, as he explained, the Alland case, the old Swedish case, is very important here. What's also important is that the Commission actually, excuse me, it used the opportunity to intervene in the case before the Consiglio di Stato, before the Council of State in Italy, in the form of an amicus curiae, which it's entitled to do. And so it could appear before the court and give its opinion on whether or not these certificates were a form of aid or not. It's a complicated case because it concerns imported electricity from Switzerland. And at a certain time, there had been a treaty between Italy and Switzerland on the mutual recognition of these green certificates. But it was found in the case called Green Networks that treaty was actually illegal because it should have been concluded by the EU and not by Italy unilaterally or bilaterally with Switzerland. So it should have been an EU competence. So this will be an interesting one to watch. And as we just heard, we should have the Advocate General's opinion on the 3rd of December. So we'll be one stage further on this case. Thank you. So that's my roundup of the two coming up. Thank you.
Thank you very much, Lee. We have I don't know, one question going back in the question and answer box. We have one question going back to the Hinkley case. It seems to be the star of the day, as to whether the ruling can be seen as a clear trend by the court to place environmental principle higher in the ranking, not only in the concept of state aid, but also in the application of the Treaty on the Function of the European Union, secondary legislation, also in respect to the context of Euratom area activities. I don't know whether, if this is a trend or is just one case, whether the case should be read beyond its implication for the specific circumstances. I don't know who wants to pick it up.
Well, maybe I could go first. I think it does signal an important trend that the court is increasingly invoking these general principles. And what it means is that if a project that is to be financed through state aid contravenes these principles, then it cannot be financed. That's a very important takeaway from this case. If it can be established that the development in question contravenes environmental legal norms, then it cannot be financed. And that's also quite a big development in this case, which I think is quite concerning for the Commission and the legal services, as far as I can make out. I don't know, Liliana, do you want to comment there? I don't know if she heard me.
Liliana, you might be, can you hear us?
Yeah, sorry. I was debating with my mic. Yeah, well, it's difficult to say. I think it was mostly of political type of decision, and I even wonder why the court took this position whereas we are talking about the UK, and the UK will no longer be part of the EU in the next in the next month. So I wonder whether it was considered as an opportunity for the court to say something that it wouldn't have said in another context, or whether it was really a mistake or a political decision. But considering how high environmental principles are considered today in purely political terms, I wonder whether this position of the court is wise, both from a legal and from a political perspective. So I hope it's not a trend. As you, Lee, I'm expect to see some evolution in the next case.
Sorry, from a totally non-lawyer perspective, a similar consideration is coming in many of the energy areas in Europe. For example, network planning. Now there is much greater consideration of the compatibility of any new development with the environmental, the climate targets. So it seems that, you know, I mean, obviously the court is not part of the policy-making construct of the union, but it seems that there is a trend more generally at the moment to try to condition any money spent to move towards the environmental climate objectives. So you know, this is just an observation that, you know, it seems to happen also in infrastructure, where, for example, the Connecting Europe Facility money, which is a bit of, you know, money given from the union budget for specific projects, there are calls for them to be actually subject to the conditionality that the project helps in achieving the, you know, the environmental, the climate and energy policy objective. So obviously the court is not, as I said, part of the policy-making construct of the union, but I wouldn't be surprised from a non-lawyer point of view if they also align to the greater interest of Europe.
Yeah, I think that's indeed something that will happen increasingly. That many decisions will be challenged for their failure to take these principles into account. One thing, of course, with state aid is that we have very strict standing rules. So the parties that would perhaps most like to invoke these environmental principles, such as the NGOs, will not usually get to the European court to do so. They will have to go to national courts. But of course, this is an important signal to national courts as well, that these principles are you know, higher law now. So I think that we could see them being invoked increasingly, and indeed decisions such as the Connecting Europe Facility and you know, the projects that are selected as projects of common European interest under the 10-year, the Trans-European program, that kind of thing. There have been, of course, a lot of complaints about the failure to consider the environmental aspects. So we could see more challenges coming, definitely.
I have another question in the box, which I think maybe is very specific, but I'll just shoot it out. So if anyone wants to, and it's related to the Expo case, the one from Italy. Is it possible to infer from the court's questions which aspects of the case made the court question selectivity? Does anyone? I think it's a very specific question. I mean,
maybe Francesco.
Francesco?
Yes. You will understand that I am somewhat constrained in what I can say, because I'm an agent in this case. But I think from an academic point of view, and from what one could have learned by being at the hearing, I think the question on selectivity, it is fair to say that took us all by surprise, because, as I was saying, the measure to support generation from RES is selective. So far was not discussed at all. It was self-evident. I think some of that being self-evident has to do with the way in which selectivity as a test has been argued so far. I don't know. Typically, you know, all of us that come from some time with state aid know that except for taxation cases, then almost by definition, many measures are selective. It's only with the taxation that there has been a debate about selectivity. So here what we see is that the court probably is trying to to inject some of the legal test and the more elaborate, more refined reasoning on selectivity that is typical of the fiscal cases also in other areas of the economy. So, that's how we read the questions, because otherwise, honestly, it's difficult to see why is the court interested in going down this avenue. So all of us, we were, struggling to anticipate what the court had in mind. And I think the best we did was to take a shot at explaining, what was the system of reference in terms of a production of electricity, and why this was somewhat of a deviation from that general system of reference. So to plug into this case the general categories that have been used for fiscal aid. I think that's as best as I can explain, I think, this aspect of the case.
Okay, well, thanks a lot. I don't know, I would start with the last round of between Lee and Liliana, and if Fabienne wants to come in as well. I mean, what can we conclude? I know it's difficult to conclude anything from the three cases. So for more than three cases, quite different ones anyway. But could we just try to wrap it up? We have another 10 minutes. I don't know, Liliana, do you want to share your last thoughts?
Yeah, if you allow me, I would go back to one of the cases I discussed, which is not a state aid case, because we talked a lot about state aid, and there were very interesting cases. And without being egoistic, just to come back to my first case, because I really think that it has very broad impact on how EU law is implemented in all regulated sectors, energy first, of course, because it was the object of the case, but also for other regulated sectors, as I mentioned. If you allow me, I will just go back to, because I didn't actually talked much about what the court actually said. So I'll just share again my screen, so that you'll see actually what the Court of Justice in the end ruled in this case, and I'll compare with what the Advocate General had recommended. So basically, in answering the Cour de Cassation question, the Advocate General suggested to follow exactly what the Cour de Cassation suggested. That is, that directive does require that the regulatory authorities, when settling a dispute, must have the power to issue such decisions that apply to the whole period. So not covered by the contract, but the whole period covered by the directive, and it kind of limited the scope to the period of validity of the directive of 2009. And the Court of Justice went even beyond that, because it said that this article, this provision of the directive, should allow the regulatory authorities to eliminate all the consequences of incompatibilities for the entire contractual period. So even going before the period of when the directive 2009 became effective, because it said, well, the previous directive from 2003 was basically applying the same principles, so the same rules as the directive of 2009. And it kind of went even beyond what the Cour de Cassation has asked. And why was that so? Because it's one of the recitals of the Court of Justice ruling that the decisions of the regulatory authorities should allow to give full effect of EU law, and including by raising the consequences of an infringement of EU law that goes before the entry into force of the directive. So here we go really, and it's to some extent joins the discussion we had on Hinkley Point, but about the the general principles of EU law, and in this case, the primacy of EU law going beyond even what the directive said. And so the directive becomes only the context of this dispute, giving the occasion of the court to remind that contracts should be compliant with EU law. Contracts or legislation should be compliant with EU law. And therefore, regardless of when the directive started applying, the national regulator should not be limited and should erase all the consequences of incompatibility starting from the beginning of the validity of the contract that's submitted to its examination. And this is important because for me, and we have some follow-up disputes in France outside of this case, but in the context of the legislation that I mentioned earlier, that limits the retroactive effect of the dispute settlement decisions. And in my view, what the Court of Justice has said in the GRDF ruling would allow to go even beyond and to basically erase the consequences even of a national legislation, such as the one that France has adopted, limiting the effects in time retroactively, because the primacy of EU law commands that all incompatibilities with EU law be erased, and which means that even a national law should not be in a position to limit this retroactive effect. But maybe we'll have another follow-up. There's a national case coming up now to the Cour de Cassation, and preliminary question is not excluded, so we might have a follow-up of this case. This will be my end word.
Yeah, thank you very much, Liliana. Quite a strong stance, I guess. I mean, from a non-lawyer. Thank you very much for contributing. Lee, before you go, I would like to check if Fabienne wants to have last reflection. You're not obliged to, but if you want to have a last reflection to share with us.
Well, thanks for asking, Alberto. I mean, I've been following with my academic hat on, and it's just fascinating set of discussions. All I can say is, many important cases seem to be coming up. So that was an extremely useful lecture for me, I have to say, as a participant. So I want to congratulate the team for the discussion, and nothing more on my side.
Thank you very much, Fabienne. Lee.
Thank you. Yeah, I would like to actually ask. Can I ask Liliana a question about this retroactivity? Because it means then these contracts that have been entered into in good faith are then null and void, I presume, unless the national law then limits the period in question. But we don't yet have a discussion of the sort of concept of, or the role of legal certainty and legitimate expectations here yet. I mean,
it's a very interesting point indeed, because this was supposed to be discussed. This was discussed a little bit in the Court of Justice ruling, but basically the Court of Justice had referred to the National Court to check whether, in regard to the national circumstances, there is a reason for the court to consider that the principles of legitimate expectations and should counterbalance this retroactivity and limit its scope. And unfortunately, we will never know what the answer of the Cour de Cassation will be, because the case was withdrawn just before the Cour de Cassation was about to rule on it, because there was a settlement between the parties. So in the end, the case was resolved out of court. I think because the parties felt that the Cour de Cassation judgment was GRDF felt that the judgment was not going to be very favorable to it. So we might suppose that indeed all the indicators were going in the sense that principles of legitimate expectations would not have been sufficient in this particular case to counterbalance the retroactivity. But we don't have the final answer of the court. And as for the extent of retroactivity, indeed, for contracts, what the national courts and the dispute settlement body had decided, it was that the contract should be amended. So there was a kind of positive obligation, not an annulment of the contract as such, because it was necessary, but an obligation to amend this contract. And there was a lot of discussion whether this was a decision of the dispute settlement body or the regulator as such. And because if it was a regulator, then we had an issue with the retroactive application, because regulators normally take decisions only for the future. But in this case, it was dispute settlement. So the regulator decided in a way as a judge, as a court would do, deciding on the validity of the contract since the very beginning and not since the date of its decision.
Thank you.
Thanks a lot, Liliana. Lee, do you want to wrap it up before I close the
Thank you. Yes, if I could just ask Anne-Marie to put up the very last slide. We just have a list of the cases. So sorry if we go on. There are a lot of cases coming down in the pipeline, which we will hopefully come back to next year when we have the spring installment of this seminar. So we've listed them for you. They will be available. Also, of course, the slides and everything will be available. But you'll see that there's some really important ones. Of course, the hearing on the Opel decision. This is the case concerning the solidarity principle. Will occur on the 13th of January. So that will be certainly one that many people will be watching. What will be the impact of the solidarity principle and on granting exemptions from directives. And of course, we've got lots of cases concerning state aid, as usual. They never stop. So we'll have plenty to come back to in the spring. And so we hope we can welcome you back to another discussion of the jurisprudence. Thank you very much for attending.
Thank you, Lee. Well, we are now coming to a close. I would like to thank Liliana Eskenazi, Francesco Salerno, Fabian Rock, also everybody who has attended this workshop. I hope you find it interesting. I did find it interesting myself, not being a lawyer. I would like to let you know that next week, as part of the weekly series, we have an FSR talk on carbon leakage and deep decarbonization. So connect online, keep connected to our webpage where you will have all the information on that. The FSR debates, the one that Lee and I organized, will be back after the Christmas holidays towards the end of January. We will soon decide the set of topics for the first quarters, and we will advertise them accordingly. I think I just left to thank Anne-Marie for helping Lee and I to make this happen. Chiara, who has been masterminding the platform from behind the curtains, and Daniela always helping us on the background. Thank you very much. As I said, there's still a month away, but we won't be meeting on a debate again before then. Good holidays, will be different from usual, and see you on this series on the FSR debate in the new year towards the end of January. Thanks a lot, and enjoy the rest of the afternoon.